So you will learn later, no, what are the answers, no, to the question, to the questions. Okay, we are now in Chapter 2, Prosecution of Offenses. So under Chapter 2, we will discuss about institution of criminal actions, prosecution of the criminal action, intervention of the offended party in the prosecution of the criminal action, prosecution of private crimes, the complaint and information, venue of criminal actions, and amendment or substitution of the complaint or information. So let's start with institution of the criminal action. Purpose, okay? What is the purpose of instituting criminal action? To determine the penal liability of the accused, no, for having outraged the state with his crime, and if he be found guilty, to punish him for it. So that is the purpose, no? Otherwise, if the accused cannot be put into cannot be subjected into criminal action, then many would follow his his actions kay lenient lang man ang government. So in order to set an example, no, to other people, no, not to commit the same crime, so it is the duty, no, of the state, no, to prosecute criminal offenders. Otherwise, daghan kaayo ka ng criminal violations, no? It would be easy, no, for people to commit crimes. So that is the purpose, no, of instituting criminal actions. So first question kanina, how are criminal actions instituted? The answer is it depends, no? If the crime or the criminal action requires a preliminary investigation or not. Okay, if it requires a preliminary investigation, then the institution of the criminal action will be done by filing a complaint to the proper officer for the conduct of the necessary preliminary investigation. So in that case, the public prosecutor. So, file ka ng complaint sa public prosecutor para mag-conduct siya ng PI. Kasi nga, the criminal action requires a preliminary investigation. If the criminal action does not require a preliminary investigation, then you may directly file, okay? You may directly file the complaint to the municipal trial court and municipal circuit trial court or municipal trial court in cities. Okay? Or you may choose to file it in the public prosecutor, no, if you want. But in practice, but you can directly file, no, if it does not require a preliminary investigation. But in practice, we have been using the second option, no, yung filing of the complaint, no, in the office of the prosecutor, no. Yan yung ginagawa talaga. If you can notice, I did not mention about Metropolitan Trial Court because there is no direct filing in METC, no? Sabi ng rules. So necessarily, kailangan dumaan ka muna sa public prosecutor before the complaint can be elevated to the, or can be filed to the Metropolitan Trial Court. Okay, di ba sabi natin kanina na it depends, no, if the complaint requires a preliminary investigation or not. So, when can you say that a criminal action requires a preliminary investigation? If the penalty imposed, okay, by law is at least, okay, take note, at least 4 years, 2 months, and 1 day. So if the penalty is below 4 years, 2 months, and 1 day, then there is no requirement for preliminary investigation. So at least yun yung penalty. So kapag yun siya, there is no, hindi mo pwede directly file sa court. Okay? Daan ka muna ng prosecutor. So if we are going to recall the jurisdiction of the regional trial court, remember that the regional trial court has exclusive original jurisdiction over offenses with imprisonment of more than 6 years. Am I correct? Diba? So more than 6 years. And the municipal trial court's jurisdiction, yung mga offenses not exceeding 6 years, di ba? So meaning to say, there are criminal actions in the municipal trial court that may require a preliminary investigation. Kasi yung 4 years, 2 months, and 1 day na threshold for the requirement of PI, nandun siya nag-fall sa jurisdiction ng municipal trial court. So we may also say that all criminal actions filed before the regional trial court require a preliminary investigation. Diba? Kasi more than 6 years na dun. And PI is 4 years, 2 months, and 1 day. So sa MTC lang, nagkakaiba, no? Kasi nga, yung threshold, nahulog dito sa jurisdiction sa MTC. So it's either with PI or without PI. But with RTC, definitely may PI. Kasi yung penalty is more than 6 years. Remember that. Now, what is the effect of filing, of the institution of a criminal action on the prescriptive period? Now, before that, let us recall, kailan ba tumatakbo ang prescriptive period with respect to criminal actions? Anyone? Kailan ba? Ano yung rule dyan?
The day the crime is discovered by the offended party.
The day of discovery?
Offended party, the authorities or their agents.
Okay. But it depends sa it depends sa crime na nakomit din, no? Can you cite a specific provision for that in the revised penal code?
Article 91, ma'am.
Okay, Article
91.
Kindly read Article 91.
Article 91 of the revised penal code provides computation of prescription of offenses. The period of prescription shall commence to run from the day on which the crime is discovered by the offended party, the authorities, or their agents, and shall be interrupted by the filing of the complaint or information, and shall commence to run again when such proceedings terminate without the accused being convicted or acquitted, or are unjustifiably stopped for any reason not imputable to him. The term of prescription shall not run when the offender is absent from the Philippine archipelago.
Okay, so period of prescription shall commence to run from the discovery, either by the offended party or any law enforcer. Yun ba yung nakalagay dyan? Yung agent, whatever. So yung question natin is, what is the effect of the institution of a criminal action on the prescriptive period? Kasi sabi natin, it will, yung prescriptive period, mag-start siya to run from the discovery. So, any answer? Who will answer that question? Ano yung effect?
Ma'am Bawi.
Sige.
It shall interrupt the running of the prescriptive period of the
Oh,
offense
okay.
charge.
Will interrupt
Yes, ma'am.
the running of the prescriptive
Prescriptive
period.
period of the offense charge unless otherwise provided by
Okay.
special laws.
Okay. So meaning to say criminal actions prescribed, no? So kailangan once you discover the offense, you should take action na in order to institute the criminal action. Kay may prescription man siya. But once you have instituted already the criminal action, then the period of prescription will be interrupted. Now, the cases I have assigned to you, last meeting ba yun? Those cases actually discusses or discuss kaya, ano yung ibig sabihin ng filing of the complaint? When can you say that you have filed a complaint so that the period of prescription will be interrupted? So, yun ang mga cases na yun. Okay? No, yung question is whether or not the filing of the complaint before the office of the prosecutor will interrupt the running of the prescriptive period. So that's one question, or that's one issue that has been discussed in the cases. So the answer to that is yes, no? As in the case of People versus Aquino, which consider the filing of the complaint before the Justice of... Ay, hindi yan. The Justice of Peace man yan. Okay. Again, the answer is yes, no. If you filed a complaint before the public prosecutor for purposes of conducting a preliminary investigation, that will already constitute the term, the filing of a complaint so as to interrupt the running of the prescriptive period. So that's the ruling of the Supreme Court, no. Sabi ng Supreme Court, the word shall be interrupted by the filing of the complaint or information does not distinguish whether the complaint is filed in court merely for preliminary investigation or for action on the merits. Second, the filing of the complaint for preliminary investigation already represents the initial step of the proceedings against the offender. Third, it is unjust to deprive the injured party of the right to obtain vindication on account of delays that are not under his control. So, sabi ng Supreme Court, even if hindi pa siya na-file sa court, basta na-file mo na siya yung complaint sa prosecution office, it will have the effect of interrupting the prescriptive period. Now, what about special crimes committed under special laws? What is the rule on prescriptive period? Ay, ito pala, meron pala akong notes. Okay, you have there how criminal actions are instituted. Ayan, with PI, without PI. Kung with PI yan siya, it's either you file directly with the MTC or you can file to the office of the prosecutor. But ay ano to? With PI, no, baliktad. Dapat yung PI dito sa baba, sa taas without. Sorry, baliktad yan siya. So when interrupted, kapag with preliminary investigation, at the time of filing in the proper office for the purposes of conducting PI, so even if wala pa sa court, pag sa prosecutor pa, interrupted na ang period. Pag walay PI, So depende no kung unsa imuhang gibuhat na pag-institute, kung nidiretso ba ka sa korte o wala. Kaya kung nidiretso ka sa korte, di pag filing mo sa korte, it will interrupt no the period. If not, kung sa prosecutor ka, the same effect no, ma-interrupt po ang period. So cases no for this is about prescriptive period. Now, what about special laws and municipal ordinances? So, the law that will govern prescriptive period for violations of special laws and municipal ordinances is Act number 3326 as amended, no, under section 1 thereof. So, as you can see, if the penalty is only by a fine or by imprisonment of not more than 1 month or both, then the prescriptive period is after 1 year. By imprisonment of more than 1 month but less than 2 years, the prescriptive period is after 4 years. An example of this is BP 22. By imprisonment for 2 years or more but less than 6 years, 8 years. By imprisonment for 6 years or more, 12 years. Then crime of treason after 20 years. There is a recent case no, about this prescriptive period no, for special laws. The one involving the Rappler CEO. Kasi yung kanyang violation, yung crime charge niya is under the special law on cyber libel, cyber crime law. That is a special law. That special law, cyber crime law, does not provide for the prescriptive period no, for cyber libel. So there is an issue now whether or not there is an issue kung ano yung prescriptive period na mag-apply in the case. Will the revised penal code apply? No, the provisions of the RPC apply to the case of the kinsa gito siya? Si Ressa? Or will the provisions of Act number 3326 apply considering that cybercrime law is a special law? Okay? You research on that. So, still we have cases, no? So, we will discuss no these cases. Zaldivia versus Reyes, no? This case involves an offense punishable by a municipal ordinance. No, held that Act number 3326 says that the period of prescription shall be suspended when the proceedings are instituted against the guilty person. And sabi ng case na yan, yung proceeding daw referred to in the provision of Act 3326 refer to judicial proceedings and not administrative proceedings. Sabi niya dyan sa Zaldivia versus Reyes. Kailangan daw sa court. Okay? However, in the case of Sanrio Company Limited versus Lim, yung ikalawang case, that is the case involving a violation of intellectual property code. The rule is different here, no? Anong nangyari dito sa Sanrio Company Limited? There is an infringement here wherein Sanrio filed a complaint affidavit with the Task Force on Anti-Intellectual Property Piracy. Now, the issue here is that whether or not the filing of the complaint affidavit with the Task Force on Anti-Intellectual Property Piracy will have the effect of interrupting the prescriptive period. Yan yung issue dito. Sabi ng Supreme Court, yes. Based on Act number 3326, the interpretation of the Supreme Court of Section 1 of Act 3326 is that okay. Hindi niya in-explain dito sa book, no? Pero the decision of the Supreme Court here is that yes, no, the filing with the Task Force on Anti-Intellectual Property Piracy had the effect, no, of interrupting the prescriptive period. What is the job of Task Force on Anti-Intellectual Property Piracy? Special kasi sila na prosecutors, no, for these offenses or specific violations, no, for intellectual property infringements. So, although hindi siya dun sa regular talaga na public prosecutor, still they conduct preliminary investigation there. So, gaya ng rule natin kanina, yung ibig sabihin ng by filing a complaint, ibig sabihin nun, even if the case is for PI pa lang, once you file there in the public prosecutor, then it will interrupt the running of the prescriptive period. Then we have Giton Jr. versus DOJ. The issue raised was whether or not the filing of a complaint for violation of BP 22 before the office of the prosecutor interrupts the running of the prescriptive period. Same rule, no? The same ruling, no, of the Supreme Court. Petitioner's filing of his complaint affidavit before the office of the city prosecutor effectively interrupted the prescriptive period for the offense, no, they had charged under BP 22. So yun lang yung tatandaan ninyo. If it requires a preliminary investigation, diba, kailangan yung complaint file mo sa public prosecutor for the purpose of conducting PI. So pag file mo doon, interrupted na yung prescriptive period. Kung hindi naman required, dalawa yung option mo. It's either you directly file in the MTC or mag-file ka sa prosecutor. So in either case, still, no, that's the effect of interrupting the prescriptive period. Then we have SEC versus Interport Resources Corporation. Same issue lang din, no? If you file a complaint, no, for purposes of PIs, still the same ruling, no, by the Supreme Court. Now, the question earlier, no, who must prosecute the criminal action? Okay, a criminal action is prosecuted under the direction and control of the public prosecutor, even if the criminal action is commenced either by complaint or information. Why? Because criminal offenses are considered as an outrage against the sovereignty of the state. No? Appearance of a private prosecutor. So when can a private prosecutor intervene in a criminal case? The answer to that is if the civil action is not reserved, no, or waived. Meaning to say, kasi the general rule is impliedly instituted by yung civil action. So kapag hindi mo yan ni-reserve, no, for separate filing or hindi mo yan na-waive, then the private prosecutor can intervene. What are the instances that a private prosecutor cannot intervene? Number one, if he waives the civil action, yan nasabi ko kanina, reserves the right to institute it separately or institute the civil action prior to the criminal action. Okay? What about independent civil actions? Okay, under the Civil Code. Diba sabi ng Civil Code, independent civil actions are not deemed instituted with a criminal action. Okay? However, hindi ibig sabihin na yung civil liability arising from the offense committed, hindi ibig sabihin na hindi yon impliedly instituted. Kasi yung independent civil action, iba yan siya. Aside from the civil liability directly arising from the crime committed, meron ding independent civil action that you can file independently, no? Sabi ng term niya. So, if you file an independent civil action, it will not affect, no, the right of the private complainant or offended party to intervene in the criminal action. After all, what has been taken into account, no, independent civil actions are different, no, from the civil action instituted impliedly, no, in the criminal action. Kasi sabi ng batas, yung civil action lang daw or civil liability lang daw na deemed instituted sa criminal liability is yung civil liability directly arising from the offense committed. Okay? I hope you understand. Okay, prosecution of a criminal action in the MTC or MCTC. General rule, prosecuted under the direction and control of the prosecutor. Exceptions, in the absence of the prosecutor assigned, the offended party, no, can prosecute his own case or any peace officer or public officer charged with the enforcement of the law violated. Prosecution for violation of special laws, the same shall be prosecuted, no, pursuant to the provisions of the said law. Okay, we've discussed, no, kanina yung intervention of the offended party. Okay, generally, the offended party, no, can intervene, no, kasi nga, a civil liability is impliedly instituted in a criminal action. However, if the offended party has waived, reserved, or has instituted a civil action prior to the criminal action, then he cannot intervene in the criminal action. When a private prosecutor may prosecute a case, even in the absence of the public prosecutor, so in actual practice, we secure an authority to prosecute, no, from the office of the prosecutor. And had it approved, no, have it approved by the court para ma-allow ka na mag-prosecute even if the public prosecutor is not around. Pero kung na ang public prosecutor, you can prosecute, no, even if you do not have the written authorization from the public prosecutor. Kailangan lang tong written authorization if wala ang public prosecutor, ikaw lang ang mag-prosecute, no, in behalf of the state. So what is the extent of the authority of the private prosecutor? Okay, once so authorized to prosecute the criminal action, the private prosecutor shall continue to prosecute the case up to the end of the trial, even in the absence of a public prosecutor, no? Unless the authority is revoked or otherwise withdrawn. Just remember that, no? So, pwede mong tapusin yung case, no, kapag ikaw ay private prosecutor. Unless na lang, nirevoke yan ng public prosecutor. Now, let's talk about private crime since this chapter is about institution of criminal action. Okay? Generally talaga, kapag criminal action, anyone can institute or anyone can file a complaint because this is a public offense. Okay, so any person can do that. But with respect to private crimes, hindi pwede na any person lang ang mag-file. But before that, ano yung mga private crimes? Number 1, adultery. 2, concubinage. 3, seduction, abduction, acts of lasciviousness, violations of RA 7610, and defamation by way of exception. You will learn later na bakit meron tayong by way of exception dyan na open and close parenthesis. Kung mapansin niyo, what is common among these private crimes? Ano kayang common dito?
Chastity, violation of chastity.
Di ba, this is something personal to the offended party. Di ba? Sa adultery, concubinage, di ba? So, ano yung rules natin, no? If yung na-commit is one of the private crimes. Pag adultery and concubinage, it must be filed by the offended party only. So, sabi na, the wordings of the rules of court is that, sabi dito, the crimes of adultery and concubinage shall not be prosecuted except upon a complaint filed by the offended spouse. So kapag ayaw mag-file ni offended spouse ng complaint against sa guilty spouse, then the case cannot be prosecuted. And second one, it must be filed against both guilty parties or offenders, meaning to say the spouse and the paramour. So dili pwede nga ang paramour lang imuhang kasuhan. Imong ban na imong isalbar, dili pwede. Both of them should be charged, with adultery or concubinage. And there must be no consent or pardon, whether expressed or implied. Kung sa man ang implied pardon, kanang kabalo na ka nga, nangabit ang imuhang spouse niya, pagka unyang gabi kay nagdulog mong duha. So, there is an implied pardon. Nya imo rin siyang gilutuan pagkasayo sa buntag, na, atimanday nimo pag-ayo. So, murag imo na siyang gipasaylo. So, that is implied pardon. Then we have seduction, abduction, and acts of lasciviousness filed by the offended party or her parents, grandparents, or guardian, or the state. So, in order na in proper order. So, una si offended party, kung dili siya mag-file, iyahang ginikanan or guardian. Kung di pod, ay iyahang ginikanan niya. Kung di pod grandparent, kung di pod guardian, kung di pod, ang state na gyud ang mag-file og case. And there shall be no express pardon. Take note here that the pardon must be express. So, kung seduction, abduction, acts of lasciviousness, nya murag kanang gitagad lang ay murag ning ano lang ka ba gitagad lang ning murag na naka-move on ka gamay niya, nakalimot ka na siya sala nimo niya. Karon natagad nimo siya kadyot o ana. So dili na siya mag-constitute as pardon. Kay dapat expressly gyud gi-pardon nimo siya. Hindi mo siyang nagipasaylo na taka or written siya or verbal nga. Basta kay express ang pardon. If the offended party dies or becomes incapacitated before she can file the complaint, and she has no known parents, ayan, the state shall initiate the criminal action in her behalf. So, ang pasabot na ni kaganina katong in order is that offended party, kung wala ang offended party, let's say namatay siya, then yung parents. Kung walay parents, then grandparents. Kung walay grandparents or guardian, then ang state. The minor has the right to initiate an action independent of her parents, grandparents, or guardian, except if she is incompetent or incapable of doing so. Off na siya. Then violation of RA 7610, what is that? Child abuse, no? Law on child abuse. So, who can file a complaint? The offended party, parents or guardians, ascendant or collateral relative. Pero kani siya kay dili ni siya in order, no? Any one of them can file a complaint for violation of RA 7610. But necessarily dapat sila gyud naagid sa ilaha, no, ang mag-file og complaint. Kay kung dili, again, dili siya ma-prosecute ang case. Then we have defamation. Generally not a private offense. By exception, if the defamation now consists in the imputation of the offenses of adultery, concubinage, seduction, abduction, and acts of lasciviousness. So kung ang imuhang pagbutang-butang o pagpamasangil sa imong isikatawo kay ang imong gipamasangil, ingon nimo nga kabitman ka, ana, gikuan mo si ano, ana, gihilabtan mo si kuan, o, ana. So, kapag ingon ana, private crimes ang imuhang gi-impute sa iyaha, then kana nga defamation can be considered, is considered rather a private crime. And therefore, it cannot be prosecuted if the offended party will not file the case. Kailangan mo follow ni siya kaning mga rules na atong na-mention kaganina, no? Offended party, this rule clearly provides that only the offended party can initiate the criminal action. Okay? Now, let's go to complaint and information. Ala, human naman din time. Okay, time is up naman din. So, 6:30 na matataman, no?